Our next speaker, Derek Whitefield, is a commercial trial lawyer in Dykema's Los Angeles office, focusing on product, class action, unfair trade practice, environmental and insurance coverage litigation. He's tried high-exposure products cases throughout the United States. He's highly regarded for his knowledge of the automotive crash safety issues, vehicle data recording, and related issues. Derek served on the GM legal staff for 5 years in the 1980s. With that, please join me in welcoming Derek Whitefield on what to do when disaster strikes.
Thank you. It's really a great pleasure to be here. I've only been in this room once before, and it was 30 years ago. I was a national moot court participant, and when I walked in the building this morning, I thought how wonderful to be able to come back here again. I thank you all for having me, and I hope this presentation is useful to all of you. This presentation is a little different than typical CLE presentations. It's really about how we think as trial lawyers when bad stuff happens and how best to respond. But in my own life, this has become a mantra. I actually want one of these questions that I'm going to share with you on my tombstone because I believe it would be a fitting epitaph for who I am. The science underlying this presentation is the science of neuroplasticity. Many of you have probably heard of that science, but it's really the study of how our actions and our thoughts can actually affect the structure of our brains and change the outcomes we get because of how we perceive and act on reality. And so that is sort of the underlying science of this presentation. In the materials that I prepared, footnote 1 has a very interesting article in the Journal of Psychology about this science. And if you're interested in it, I commend it to you. So what we're going to talk about is what to do when disaster strikes or when bad stuff happens in litigation. And the answer is to ask a great question. The worst thing you can do when bad things happen is to start to think about how bad it is what just happened. This is true whether you're in front of a jury. This is true whether you're in your office. This is true whether something happens in your personal life. And so I'm encouraging you to think about the lessons from this talk, not just as lessons for you as a lawyer, but also lessons for you as a person. My goal here is to actually affect the way each of you, every single person in this room, practices law and lives their life. It's a really big goal for a 20-minute speech. But it's the goal that I have, and I'm really hoping that you will kind of follow along with me and indulge me in this. The great coach John Wooden was famous for coaching the UCLA Bruins to 10 national championships. He was the most successful coach of all time. He won 7 NCAA championships in a row. And he, in part, was famous because he not only coached his players to play basketball, but he also coached his players to be good people and happy people. And so I draw on the way he approached being a basketball coach as I'm sort of approaching this little CLE presentation. One of his sayings, and he had many, many sayings, was that things turn out best for the people who make the best of the way things turn out. And that is very much what we're talking about here. When things happen that you initially think to yourself, that's bad, that's an unfortunate development, you can actually look at them differently. You can ask a different question about them, and you can come to a much better result. The point here is that the field of possibilities that you generate in your mind when bad things happen in litigation is broader if you think about things in terms of how you can use something or what's great about what just happened. Other people have talked about the power of questions. One of my favorites is Tony Robbins, who's a master life coach. Many of you have probably heard of him. He's the 7-foot-tall guy who did infomercials for years and then started making $30 million a year as a personal life coach and ended up coaching people like presidents. Robbins' belief was that the quality of a person's life is dependent on the quality of the questions they ask themselves every day. And I think the quality of your representation as lawyers is dependent on the quality of the questions you ask yourself every day. He said, quality questions create a quality life. Successful people ask better questions, and as a result, they get better results. And as I said, the quality of your life, and this is my own belief too, is determined by the quality of the questions you ask yourself every day. So as lawyers, and I believe this is also fundamentally true, the outcomes you get as a lawyer are determined by the quality of the questions you ask every day. So it's time for any of you who are interested so far to write down 2 questions that I will come back to a couple times in this presentation. This is my favorite one, and it's the one I want on my tombstone. What's great about this? There is fundamentally something good, something great about everything that happens. You can be stuck in traffic, and if you ask this question, you will get an answer that is better than, I'm late for my meeting, or I can't deal with this anymore. I need to do something about this. You can find a way to improve your experience by conditioning yourself to ask this question all the time. Everyone who works with me has this question. I have a former secretary who will send me emails that say, Derek, I just had a what's great about this moment. And she will tell me about some horrible thing that happened, like her cat dying. And she will explain to me how she worked through and got to a better place because she asked this question. So I want you all to write it down, and I want you all to take it with you, and I want you all to use it. And if you do, my goal in giving this CLE presentation will have been fulfilled. The second question is, how can I use this? What about this experience that's happening to me right now can I use? What did that witness just say that is, on its surface, damning to my case, but that there is a way I can work to my advantage? And this is a very simple but incredibly powerful question that changes the way the neuroreceptors in your brain are structured, and they will work differently if you can condition yourself to ask this question. I'm now going to give you some examples. This one is not a law example. The other 3 I'm going to give you are from my own practice. This one relates to William Greatback, and I love his name because it has great in it, so that's what's great about that. He invented the pacemaker by accident. He was working in his workshop in 1956. He fought in World War II. He came home. He became a professor at Cornell, and he was an inventor. He became an inventor. He was trying to invent a device that would monitor the signals of the heart, the rhythm of the heart. He reached into a box and pulled out what he thought was a transistor that he was carefully deciding a resistor that he was carefully deciding, this is the resistance I need for this piece of equipment. Put it in the device, and lo and behold, it didn't do anything like what he thought it was going to do. But its electrical pulses mirrored the pulse of a heartbeat. He got a signal that lasted 1.8 milliseconds, and then it stopped, and then it started again. And he said to himself, that sounds like a human heart. And for the next decade, he worked on perfecting a device that ultimately has saved millions and millions of lives. So the lesson from the William Greatback example is similar to this ask a great question, but it's don't fear mistakes, live by learning from them. The same questions underlie that lesson, right? What's great about this? What's great about what happened to him in the laboratory that day? How can I use this? How can I use what just happened to me in the laboratory that day? Take that into your practices, and I guarantee it will make you better lawyers. My next example comes from a case I tried in Doylestown, Pennsylvania, just north of Philadelphia. It involved a senior executive vice president from a company who is represented by several lawyers in this room. He was tragically killed in an automobile crash, and his daughter and wife, bereaved, filed a product liability case, and they claimed that the car was defective and that was why he died. We were in trial. It was about the third week of trial. I was about to put on the leading engineering expert for my client, Honda. And without having filed a motion in limine, without having given me any clue this was about to happen, plaintiff's counsel stood up and objected to all of the expert's testimony and all of the exhibits the expert was about to use. The judge who had it in for us, and I won't name names, but who clearly thought that we should have settled the case and was trying to move the case toward resolution, decided to split the baby. He let my witness testify, but he struck all of our exhibits. There were 15 exhibits that explained some of the most complex concepts that we had, over a period of years, honed to a point where we thought the jury could actually follow along and understand what the defense of the case was really all about. He struck them. I had a what's great about this moment at that moment. I asked myself my favorite question, and I thought to myself, this could turn out to our advantage, because my witness now has to go through everything that we spent that period of time, and I mean a couple of years, doing in front of the jury. She had to pull out the actual specifications from the discovery that we had produced and show how the calculations were made. She did everything on a blackboard, actually on a flip chart, in front of the jury. We marked page after page of her notes. The jury was sitting on the edge of their seat, instead of potentially being maybe a little bored by what turned out to be a fairly canned presentation. We got a more spontaneous outcome. We demonstrated her ability as an engineer, and I think some of the jurors were a little skeptical that this very attractive, fairly young woman was in fact an airbag design engineer. It was more compelling, and frankly, it made it much harder for plaintiff to cross-examine the witness. And so I believe, and I draw on this all the time, that that moment was sort of the validation of this question being as powerful as it really is. My next example is actually a little bit embarrassing, but sometimes we learn from mistakes, and so I'm prepared to tell you about one. This case involved a young man. He was 18 years old. He was using a forklift when he lost his leg. And he hired one of the best trial lawyers in Los Angeles, who has been named LA Trial Lawyer of the Year several times. I was fairly new to Los Angeles, actually, when this case was sent to me for handling, and so I was just a little intimidated by the fact that I was working against Larry Booth. We spent a couple of years analyzing what happened in this incident. You know, it was a workplace situation, and the guy was obviously very seriously injured. We needed to figure out if we could actually defend the forklift design. We hired a couple of experts. We decided that the plaintiff's story, after I took his deposition, was impossible. We decided that what he testified to could not have happened. And so we devised a very intricate series of tests that took place over a period of several hours. And we demonstrated that plaintiff could not have been telling the truth at his deposition. It didn't happen that way. He had to have been horsing around with the forklift. That's how he was injured. Great. Testing went perfectly. I was very excited. We were getting ready for expert disclosures. In California, the law is that experts are disclosed just 50 days before trial, and then you get to take depositions of all the experts in that period between 50 days and 15 days before trial. It's an insane way to litigate complex product liability cases, but that's what we do in California. It's not the only insane thing in California. I come into my office on a Saturday morning, and I'm going through some materials getting ready for expert depositions. I go into my paralegal's cubicle, and I find a letter, And my paralegal, instead of sending the videotapes and reports from this testing to our client and our experts, sent the test report to plaintiff's counsel. And for about 5 minutes, the blood drained from my face, and I thought my career as a trial lawyer was over. Until I asked this question. And I thought to myself, Larry Booth has no idea that I did not intend for him to get our testing. And now that he has our testing, his experts are forced to have to deal with this testing before I take their depositions. And I started to build this new way of approaching this whole issue, the testing and the defense of this case, from this question. And literally decided that the mistake my paralegal had made, for which she paid dearly, was actually a good thing for our case. Then I thought, what is Tony Russo at Sumitomo going to think about what just happened? How am I going to tell him? And I thought to myself, what's great about this? And I thought, Tony doesn't know me very well. This is an opportunity for him to know I'm an honest lawyer. I will always tell him what's going on in his cases. And if, after we talk about what happened, he wants to fire me, I will be okay. I will still have a job. I will still have my house. I will still have my family. I will be okay. And I told Tony the following Monday, and he was concerned about what happened, but he was also grateful to have been told about it immediately after I discovered it, and he concluded that what had happened actually was in fact beneficial to our case. And lo and behold, I got a call from Larry Booth the following day, on the Tuesday after I told the client about this, and the case settled for a number that I can't disclose, but I wish I could. So my last example is about kind of what we call bad facts. Sometimes we evaluate a case and we say there's bad facts in this case. In one case I tried in Broward County, the bad fact, everybody thought, was the fact that the plaintiff was a 7-year-old girl who was a C1 level ventilator-dependent quadriplegic. It doesn't get any worse. And we tried through motion practice to require her to be there for voir dire. We failed. So during opening statement, there was a dramatic moment when the courtroom doors flung open and in came little Ashley Moore with her grandparents and her helper dog and her maid and all the people who support her. And I thought to myself, how can I use this? Because there was nothing apparently great about it, but there was. It gave us an opportunity to demonstrate what good people we were in front of the jury. We were able to show our humanity. We were able to show that we could care about what happened to her and treat her with kindness and respect. And that gave us a position, at least a place to work from, given how difficult that situation was. So I'm going to wrap this up. My conclusion about facts is that there are no bad facts. They are just facts. The question is how we process them and what we do with them. My view is when bad stuff happens, when stuff happens, they didn't want me to say the word with the I in it, you've got to embrace it. You've got to find a way to use it to your advantage. That's the way it is. And the two questions that I use to do that and that I commend to you and that I hope you've written down by now are what's great about this and how can I use this? Thank you very much.